So he's having this conversation with someone he believes to be a minor, and then he agrees to meet up with the minor.
He said he was too sick to be dangerous, yet drove to meet someone he believed was a minor. The judge saw through everything and made a decision that changed his life instantly.
All right, you entered a plea of guilty on July 18th.
Yes.
According to your plea bargain, and you entered a plea of guilty to counts 1 and counts 3. According to your plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $4,000 fine. The state opposes your application, and there's to be Chapter 62 compliance. Have both parties had a chance to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any objections?
Judge, there's no objection to the PSI, but I think Mr. Lott, I know the court's familiar with his medical background. He's had a couple of seizures in the courtroom, so he gets nervous. He's asked me to communicate to the court that he would like to retract his statement to his PSI officer, where when asking about the instant offense, he made an excuse for his behavior. He accepts responsibility for his behavior. I know that because prior to the PSI, he and I have had that discussion. I think he gets nervous in settings and I think the answer he gave is a reaction towards self-preservation with his family and his friends, and he's just very ashamed of his behavior. So I think the best we can say today, Judge, is regretfully, we don't want you to think he's making excuses, because that's certainly the way it reads. He's here today to take full responsibility. His sister and his wife were present to testify on his behalf. He's just struggled with shame and humiliation this has brought to his family.
All right, any witnesses?
Yes, Your Honor. The first witness I have is Cecilia Jenkins Lott, his wife.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
My name is Cecilia Jenkins Lott.
All right. And if you may proceed.
Yeah, proceed. Ms. Lott, good morning. Thank you for coming down. You understand we're here today for the sentencing of Frankie Lott. Is that correct?
That's correct.
Would you explain your relationship to the judge of the Frankie Lott?
I'm his wife. We've been married for 4 years.
And can you tell the judge how long you've known Mr. Lott prior to being married? How long you dated him?
We dated for 10 years prior to our marriage.
Did you grow up here in Bexar County?
No, I'm originally from Detroit. I've lived in San Antonio since 1984.
And can you tell the judge what your work background is, Cecilia?
I've been in the legal system working with attorneys since I was at age 18. I worked in litigation for over 30 years, and I've been in real estate for over 10 years.
And you're currently working in a law firm, is that correct?
Yes, I work at a real estate law firm.
Ms. Lott, can you give the judge some background? I know it's very long, but just kind of an overview of Frankie's medical conditions as he stands here today.
He was diagnosed with MS about 3 months after we got married in 2021. He's since subsequently been diagnosed with rheumatoid arthritis. He used to get shocks in his back and his neck because his lumbar and his cervical disc are degenerative.
And is he currently under medical care and medication?
He hasn't seen his general physician in 1.5 years since he lost his insurance. He sees a psychiatrist every week, sometimes twice a week, because he'll see an intern and a doctor. He is currently on medication. The psychiatrist just added a third, an antipsychotic. He's on depression medicine. He has patches for the pains in his back.
And prior to his arrest, Cecilia, can you tell the judge about his work background?
He actually worked for Criminal Justice Center. He worked there for a few years, leading up till January of 2024.
And you are certainly familiar with the charge that he's pled guilty to 2 counts to this court, is that correct?
That's correct.
And you're not here today to make any excuses about that?
Oh, no, I think he did something stupid.
And has he indicated that to you?
Yes, and he's apologized profusely, and he just thinks he did something stupid.
You are aware that, I guess prior to this arrest, he really has no criminal history to speak of.
No,
He's been on bond for an extended period of time, is that correct?
yes, since January of 2024.
Has he been on home arrest, is that?
Yes, that is true.
And has he abided by all the conditions of his?
Oh, yes, I am the warden.
So you know that one of the decisions that we have agreed to leave up to the judge is whether she would give Frankie time in prison or a shot at community supervision. Do you think he's a good candidate for probation?
Oh, yes,
And can you tell the judge in your own words why he's a good candidate for probation?
because he repents for what he did, and he has health issues that would make it impossible. He has health issues. He has repented. I believe that he would be okay at home. I've changed the phones. He's not allowed to have text messages or anything on his phone. I'm there. I monitor. I control the phone. I turn it off at night at bedtime. And he's homebound. He only leaves to go to his doctor's visits or to pick up prescriptions. And he's not allowed to do anything but be at home.
And obviously, I think your statements include that you would be supportive of him if he were placed on community supervision.
Oh, yes.
Is there anything else that you would like to tell the judge, Cecilia, that you would like her to take into consideration and make a decision about whether to give him probation or prison time?
He's actually a good guy. He was brought up to protect everyone. He's the oldest, so he looks after his brother and sister. He adopted my adult daughter who thinks he runs the world. He's a good guy. He just doesn't always think things through, and he sometimes does things that are stupid.
All right, well, that's succinctly put. Thank you very much, and Your Honor, I'll pass the witness.
Thank you.
Just a few questions for you. Good morning. I just have a few questions for you, okay? You said that he was working in the criminal justice system up until January of 2024, correct?
Yes.
And in January of 2024 is right when he committed this criminal offense?
Right, and that's why he lost his job.
And I know I'm grateful for it. And you say, you control his phone and you control everything he does, but can you tell me in this report what he's done himself to take accountability for his actions? Because I appreciate it, but he is a grown adult as well, right? So he should be able to control his urges and his actions. So what have you seen him since leading to this case do in that regard?
What do you mean, like
Just make sure she can hear you.
outside of the home?
Or just
Well, he's very apologetic. He can't do anything or go anywhere. So, I mean, he knows that, and he feels bad for what he did and how it's affecting the entire family.
okay, no further questions for this witness, Your Honor.
May she be excused, Your Honor?
Yes, thank you so much for coming to talk to me about it. Hi, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Do you need to take a breath? Okay. Just let me know when you're ready to proceed, okay? Yes.
Dolores, if you would, ma'am, just take your time and speak into the microphone, state your full name for the record.
Dolores Brown.
Just a little louder.
Dolores Brown.
Can you tell us how you're related to Frankie Law?
He's my brother.
And would you describe your relationship with Frankie?
Yes, we've always been close. Growing up, we've had fights. My mom always told us that to make sure we take care of because we're all we have. And just love him so much. I have handled this situation that has occurred. It's very hard and difficult on a family, including my dad. We just lost my mother right before the incident happened. And that's why it's just difficult for me to stand this. My dad is deteriorating. And if anything, my brother does go to prison, he's not gonna make it. I know it's not gonna make it. It takes too many medications.
You've done good. Let me just ask you a couple of questions. Just a little bit. Okay, and just speak loud enough. Microphone here. You've certainly come to court every time we've been to court. Is that correct?
Yes, sir.
You understand exactly why we're in front of Judge Ford this morning.
Yes, sir.
She's got to make a determination whether to give Frankie prison time. There's a range in that we've limited, and there's certainly an application for supervision. Where that is, I'd like to ask you if you could just, you've known obviously your brother and sister, but could you tell the judge some of the good qualities of Frankie that would make him a good candidate for probation?
Well, he's always protecting me, and he was with you. A lot of times he was better to me than my siblings. And all I can tell you, Your Honor, he regrets everything that he's done. Put shame on the family. Bringing shame to my dad, especially after just losing my mother.
Let me ask you, if he's granted probation, does he have the continued support of your family?
Yeah, absolutely, Your Honor.
You in Frankie's life every day?
And ever since this incident has been, Your Honor, and with his medical condition, I've been checking on him more, been making more contact. Just trying to ease his mind, to let him know that, we all make mistakes and, that we all make mistakes and you have to own up to your responsibility and he does show the remorse for what he's done and the shame that he brought on his wife,
And if he is granted probation, will you remain in his life in a supportive capacity?
Your Honor, if you were to
Go ahead.
if you were to grant him probation, I stand here as a woman and I can guarantee that nothing like this will happen again. And if you can attach me to any type of documentation, because I'm not gonna perjure the court, and I can guarantee that this will never happen again or anything else going forward. Thank you.
Go ahead.
And I'm scared of you myself, and what you can.
All right, so this is what I want you to know, and all of the witnesses who testify. Because people always are concerned, did I say the right thing? Did I say too much? Did I not say enough? But I want to let you know that you're giving me insight into your brother. I want you to know that there's nothing that any witnesses that have come before me that have said anything that has hurt him. All right?
Thank you, Judge.
All right. Do you have any questions? All right. Thank you.
Judge, lastly,
State, are you still, you've heard testimony. Does your plea bargain still remain the same?
Yes, Your Honor.
All right. Yes, I'll hear you.
Judge, I think we've been to court numerous times, and I think the court can remember some of the health struggles that Mr. Lott has had, and I think the probation office did a good job of documenting his medical history from.
And just here's my question with regards to the medical history. Is this something that's brand new, or were these medical issues, a part of these medical issues, a part of when this incident occurred?
I think his MS symptoms started in COVID, although he was able to work through it, but I think his work was limited. Certainly his arthritis and back issues have outdate the origin of this case,
So he's had these conditions prior to the commission of this offense?
yes, ma'am.
Okay. All right, you may proceed.
And so, Judge, I think the court's aware of it. Obviously, we put a date on it now. I can't tell you how long before the commission of the offense, but certainly the toll that it's taken on him has been significant. But, you know, he stands here today, Judge, as a 57-year-old man. I think there was one hiccup that I was reminded of reading in the PSI today, some selling alcohol to a minor when he worked in a restaurant, I guess, back in 2002. I hope the court won't hold that against him. I think other than that, he's lived his life being a good man, making good decisions, and certainly being a productive member of our community. And then he makes this mistake, Judge. It's a whopper. We get that.
All right, so here's my question. And counsel, maybe you can address this. Maybe you want your client to address this. So there's an online solicitation of a minor, and I am completely, I'm going to disregard the fact you want me to disregard, where he says that basically he was tricked. And I understand with online, I represented people before. I understand with online solicitation of a minor, you are sort of tricked in the fact that you think you're talking to a minor and you're not talking to a minor. So I understand the trickery in that portion, but this is what I want to address. So he's having this conversation with someone he believes to be a minor, and then he agrees to meet up with the minor. And he has all these medical conditions. No, that's what it says in the stipulation, that you actually agreed to meet up with the minor, and they arrested you, I believe, at the meet.
They arrested him on the scene where the undercover cop and Mr. Lott agreed to meet.
So he has medical issues. He has the MS, as you're saying, arthritis, all of these chronic issues, but he is holding a conversation with someone he thinks is a minor, and then he goes to meet up with the minor with all these conditions.
Well, Judge, if you're asking us to make an excuse to him or not,
No, I mean, I'm just,
guilty to it.
no, I understand he's pled guilty, but I'm trying to figure out the status of his medical issues.
Well, you know, Judge, I don't know whether he was, you're asking me if you felt okay to meet up that day or what the situation is. I can tell you that he's not feigning his medical issues.
Oh, no, I believe his medical issues are real, based upon the PSI and based upon issues that he's had when he's in the courtroom. I'm just trying to look at him globally so that I can make an appropriate decision on punishment in this case.
Well, you know, I don't know exactly what the court's looking for. I certainly think he had medical issues that day, at that time during his life. Now, whether he felt okay to get into a car and go to a meeting, sounds like he did. So, but I can tell you that was how long ago? A
Mhm.
year and a half ago or some months ago. So I can tell you from his family and talking to him, his medical condition has deteriorated. So, and I think that's obvious to everybody. So hope that answers your question.
Yes, and that's what I want to,
Yeah.
for you to elaborate on that part.
Yeah, so it has, Judge, I think you've seen it. I think these ladies, to the best of their ability, have articulated that. As his wife said, he's homebound.
Mhm.
He has nowhere to go. She's in charge of his phone. He's not going anywhere. He's lost his insurance, so he's at the mercy of the state. I think that if he were not taking this serious, then he would have violated the conditions of his bond, and it would have been a nuisance to the court a long time ago. So this mistake happens. He's was afraid of losing his family. He's been able to maintain a relationship with his family, except time doesn't do anything with him except make his health worse. So I think medically, Judge, he's a good candidate for probation. I think, quite frankly, if he would go into the system, he's a burden to the system. That's not making an excuse for his behavior. But if the court wants to look at this situation globally, he's got a support group. He's going to have to register as a sex offender. His health is deteriorating. It's not going to get better. He has his wife lives at home with him. His sister's in his life every day. Brother, from this letter, has asked the court to not lose sight of one bad decision in a man's life, but perhaps to punish him for his goodness as well, because he's not a man with a criminal history, no drug or alcohol problem. I think it was a mistake that the court has seen a lot of men make. He made it, and as his family and the very strong women in his life have stated, they don't expect that he'll make another mistake. They just want the opportunity to care for him in these years of need and take care of him. And that's all we can offer the court.
All right, state.
The state, just looking at the PSI, Your Honor, our concern is, I know that they've retracted today what was on the PSI, but our concern is the same as what he told the cops to what he said here, is that his goal was to go find this child and tell her she shouldn't be doing this, and that, trying to find who her parents were so that he could tell them. And the state's concern is that he wasn't taking accountability then. He wasn't taking accountability when he did the PSI, only today when he's coming forward to the court, Your Honor. And that the excuses for the types of conversations that he was having with what he believed to be a 14-year-old girl on the internet, and then proceeding to meet up with that individual that he believed was a 14-year-old minor. That's just the state's concern, Your Honor. He had these health conditions. While they may have deteriorated, he had them. He drove a car. He went to meet this individual, Your Honor. And that's pretty much all the state has, Your Honor.
All right. All right, this is what the court is going to do. And the court is taking in consideration your lack of history. The court is taking in consideration your medical conditions. The court doesn't believe a sentence should be a death sentence unless it's called for the death penalty. And I say that if somebody is receiving the death penalty, all the other sentences, they're not supposed to be a death sentence. So I'm taking all of that in consideration. I'm taking your health in consideration. The court is going to find you guilty of counts 2 and counts 3. Counts 2 and counts 3 will run concurrently. There's to be Chapter 62 registration, and the court will sentence you to 2 years in each cause number. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, And because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. Court is calling 2025 CR 005777, State versus Alexander Roca. Can I have parties announced for the record?
Megan Galloway for the state.
Alex Shar for Mr. Roca.
And are you Mr. Roca?
Let's see.
Let me see what page you're on. All right, you entered a plea of guilty on June 20th. There was a request for a PSI and TAP evaluation. Have both parties received the PSI and the TAP evaluation?
Yes, Your Honor.
Yes,
Any
Judge.
objections?
Not from the state, Your Honor.
Judge, I don't have any objection to the TAP evaluation. I did want to be heard on the recommended conditions of deferred adjudication.
All right, according to your plea bargain agreement, there's $1,000 fine. State recommends deferred adjudication, and there's $60 to DPS. All right, counsel, do you have any witnesses?
I do not. Judge.
All right, state, any witnesses?
No, Your Honor, this is a case where the state probably recommended deferred adjudication. The Honorable Judge Raymond Angelini was presiding, and so he did order the PSI, and so I don't have.
All right, anything you wish to say on behalf of your client, and state you may be excused.
Judge, the recommendations that were made by the officer on page 10 of the pre-sentence investigation report. Now, yes, this case started off as a DWI case.
Mhm.
But it wasn't a drinking while it wasn't a driving while drinking intoxicated. When they stopped him, they found the marijuana in the car. He had admitted to smoking marijuana earlier in the day. They did testing, and they didn't test for alcohol, gave a breath samples, but they did test for Delta-9 THC,
Mhm.
and it came back above the level.
And if he's drug tested today, what are the results going to be?
He tells me he will be negative.
All right, he's going to get drug tested today, but continue.
Certainly. And so, I understand that the state outside the plea agreement recommended that he have ignition interlock for half the term. Well, that device, just tests for alcohol, ethanol. And not for, for marijuana or cannabis. So I don't think he needs the ignition interlock, but more importantly, they're recommending that he cannot drive at all for their full term of supervision. And he is working, and in fact, I need to update the court.
All right, so I don't see where that says no driving. And no, that is a recommendation by probation. I thought you meant that was a recommendation from the state.
Well, just the ignition interlock was recommended in the plea agreement, well, outside the plea agreement,
Mhm.
at the bottom of that page. But the probation officer was recommending no driving for the full term of supervision.
Mhm.
He has, he's living with the mother of his children, they're together. He does have training as a barber, but within the last 3 weeks, he started working for Vivint, which is a home security company. He's a salesman for them. He works Monday through Saturday. And that's the type of job he's doing now. He needs to be able to drive. He needs to be able to, for work and to take care of his family. Mother's children also works 50 hours a week. And so they're doing everything they can to live and take care of their young ones. And so really, I don't have any objections to the TAP evaluation. I would just ask the court to, not impose the ignition interlock.
All right, let's do this. You say you're gonna be negative? All right, so I'm gonna have you go do a drug test and then we'll come back and I will make a decision on your application. All right, so this is what the court is going to do. The court will sentence you to 2 years deferred adjudication. There's $1,000 fine.
Sorry, just one moment.
No problem.
30.
All right, the court is calling, well, we're back on the record in 2025 CR 005777, State versus Alexander Roca. Okay, they tell me that you were negative, which is great. So it seems that you've learned some things, okay? So there's going to be 2 years deferred adjudication, $1,000 fine to be probated. There's $60 to DPS for testing. Proof of employment within 30 days. No employment as a home health care provider or with minors. Do you have children?
Yes, ma'am.
And what are their ages?
2 and 7 months.
All right, there's a 200 hours community service restitution. That will be deemed satisfied upon completion of parenting classes. There's to be regular reporting by Zoom or in person, regular random UAs. State, on this case, he's just charged with possession of marijuana. And outside the agreement, you all have DWI education, victim impact panel, ignition interlock for half the term.
Judge, I would, waive the ignition interlock just because, and the reason that was the recommendation is because there's common misdemeanor to DWI, least years of 10 search for, so I would still request a classes will waive, ignition interlock as alcohol was not a factor.
All right, there's the DWI education course, the victim impact panel. Field visits 1 time per month for 4 months. Probation, is there anything else that he needs?
Okay.
Is there anything else you need from the court in order to be successful?
No, Lisa.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, counsel, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
In order to be successful in this court on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel as though they're not addressing that, you can always come back to the court. Do you understand? All right, good luck to you. All right, court is calling 2025 CR 011456, State versus Antonio Valentin Corrales.
Correct.
Could I have the parties announced for the record?
Juan Espinoza for the state.
Carl Alexander for Mr. Corrales.
And are you Mr. Corrales?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
To the best of my knowledge, the state has complied with 3914 judge, and yes, I have reviewed the evidence for my client.
Ms. Corrales, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am. I reviewed it.
Did you review the true bill of indictment with your attorney? Did you understand it?
Understood.
Counsel, do you waive the reading?
Yes, Your Honor.
Okay, are you proceeding as on the indictment as presented? Yes, you are.
Okay, yes, Judge.
Ms. Corrales, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am. I signed it.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I agree.
Did you understand, if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so. I will add, he was evaluated for competency. Mr. Corrales is intellectually disabled. We did have a judicial determination that he is competent to stand trial.
Okay. And do you believe he was sane at the time of the offense?
I believe he, yes, meets the legal definition to have been sane at the time of the offense. Yes, Your Honor.
Mr. Morales, has anyone threatened you or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than your plea bargain agreement that you've reached?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I'm satisfied.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I read it all. I understand it, ma'am.
According to the plea, there's $1,000 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. They're taking in consideration 2025 AL 003247. Did you understand that to be your plea?
Understood.
Defense and state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understand.
Any such motions?
There were only bond motions, Judge, so.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, the mixed supervision, no possession of firearms, MRT, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
Excuse me, we have reviewed the same, no objections.
All right, did you review the waiver and stipulations with your attorney? Oh, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, and I do have a few items to address before the.
Yes.
So first and foremost, I guess I had been dealing with Ms. Galloway. She's not present. I did submit these documents to her earlier, but I'd like the court to consider them. So they've been marked as Defendant's Exhibit 1 and Defendant's Exhibit 2. Defendant's Exhibit 1 is a disability determination explanation that was used in ascertaining whether or not Mr. Corrales qualified as being disabled for purposes of Social Security disability insurance. And then State's Exhibit 2 is that actual determination as well, showing that he has been in fact labeled as disabled by the U.S. government. As I mentioned before, and which you'll find in those, is Mr. Corrales is intellectually disabled. He's also been diagnosed as schizophrenic, as well as suffering from ADHD. There were a couple of items I did want to address in the STIPs and the court deciding whether or not to go along with the plea bargain number 1, but also in how long the probation would be for. And that's where Ms. Galloway and I kind of were at an impasse is how long the term should be.
Okay.
We're asking for something less. The state is asking for the maximum period of supervision possible. We're asking for something less. This is not an instance in which we have a thug who just runs around shooting people. Mr. Corrales, because of his disabilities, does not have the same ability to engage in decision-making that you or I have. In fact, his parents who are present here actually have been awarded guardianship over him by a court. When Mr. Corrales turned 18, he was residing in the state of Utah. Courts there felt that he could not take care of himself or make decisions for himself, and therefore his parents were appointed guardians over his person and estate. They went on a vacation and left him alone when this happened. They are committed to supervising him, making sure that he succeeds. They have been monitoring him ever since he has been out on bond for this. They are the ones that actually retained my services, as Mr. Corrales himself really only has his Social Security income that he gets. So actually, I'm going to ask you to probate the fine as well. But in the reports, Judge, there's some things that I think on paper look bad that bear explanation. One, Antonio, as a young man, actually managed to become an Eagle Scout. He did engage in shooting sports, and one of the things he was taught to do, and that's ingrained in him, is that you pick up your brass. I know the detective went out of his way to point out about how Antonio picked up the shell casing, so that explains that. The detective also writes that Antonio walked out of the location. Discussing that with Ms. Galloway, and she agrees with me. The video shows a different story. And it's talked about a little bit in the press guide. A witness by the name of Michael actually engaged in a physical altercation with Antonio. And it was Michael that forced Antonio to leave. So it wasn't that it was a cold-hearted, just I shot someone and I'm departing. Antonio was forced to leave, Judge. And so I think that makes a difference when we're evaluating cases like this. Antonio needs help. He needs to be in the MIC unit. He needs supervision. He needs the kind of help that unit can provide and that his parents are committed to helping him with. The court may remember during the pendency of this case, he was also hospitalized for his mental health and actually missed court, and we had to provide proof of that. He has had some suicide attempts in the past. He has engaged in some self-harm, and a lot of that is actually talked about in the narrative portion of Defendant's Exhibit 1. My concern with what the state wants with 10 years of deferred is that long of a period with a young man who has the deficits that Antonio has. Is we are exponentially increasing the likelihood that he will mess up on some sort of technicality. The court can certainly extend him if he has a minor violation. And obviously, and I had to explain it to him a few times, but he understands that if he were to violate, the court also has the full range of punishment if the court chooses to revoke the deferred adjudication. But we're asking that you at least start him off somewhere on the lower end of 3 to 5 years, which I think is certainly enough time to see how he does, to see if he is rehabilitated, if he has learned from what he did. And if he needs a little more time, then the court, of course, can always extend him up to the 10 years. But I think the 10 years, when you look at the totality of who he is and how this all came to be, I think 10 years is excessive.
All right. I'm gonna allow defense counsel to withdraw defense exhibits 1 and 2.
Thank
And
you.
if you'll give those to probation.
Sure.
This is what the court is gonna do. Court is gonna sentence you to $1,000 fine that will be probated. Regular reporting by Zoom or in person, regular random UAs. Is he going to remain in San Antonio?
I believe so.
Yes,
Yes,
ma'am.
yes, his parents are nodding yes.
All right, taking consideration 2025 AL 003247, 6 years deferred adjudication, no contact with the complainant, no possession of firearms or ammunition. There'll be a referral to Center for Healthcare Services, the Mental Health Initiative, 200 hours community service restitution. Once he's completed hostility management course, 100 hours will be deducted. The remaining 100 hours will be deducted upon completion of the MRT. Proof of SSI or proof of employment within 45 days. No employment as a home health care provider with minors. Are there any minors living in the household?
I don't believe so.
No.
Yeah, okay. There's to be no unsupervised contact with minors. No residing in households with minors. No contact with the Whataburger that's located at 8002 Fredericksburg Road. And field visits 1 time per month for 8 months. Probation, is there anything else?
No, good.
All right, is there anything else that you need from the court to be successful?
Just, I wanna be an electrician, so I wanna go to school.
Okay,
Let's finish your probation first. Okay.
Judge, mental health and make supervision or no?
yes, mixed supervision. All right, and I'm sorry, there's an affirmative finding of deadly weapon.
Yes, ma'am.
All right, to the parents, is there anything else he needs or they feel he needs?
Feel good?
All right. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. Here's the thing. Whenever there are disagreements between people, when you see it's ramping up or escalating, just walk away. In the words of my grandmother, you know what she would always do? She'd walk away and she'd say, somebody got to have sense. And so she'd just walk away. So in your mind, you can say, somebody got to have sense and just walk away. Okay? All right, good luck to you.
Thank you.
You're welcome. Thank you for dressing appropriately for court. You always do, though. I appreciate that.
I appreciate it.
All right, thank you.
The state pushes for strict conditions, warning of the seriousness of the offense, while the defense argues that long probation could set him up to fail. In the end, the judge strikes a balance: 6 years deferred adjudication, intense supervision, and one clear message. Next time, walk away before it escalates. Fully his own.
All right, court is calling 2025 CR 008182 State versus Jay Taylor. Can I have parties announced?
Megan Galloway for the state.
Attorney Wilson for defense.
And are you Mr. Taylor?
Yes, ma'am. How you doing?
Doing great. How are you doing?
Doing good.
All right. Did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision with your attorney, and did you understand it?
Yes, ma'am.
All right. Are you the same J. David Taylor who was placed on deferred adjudication in 2025 CR 008182 for the offense of robbery on August 18th, 2025 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report supervision officer as directed for the months of November and December 2025 in violation of condition number 4.
How do you plead to that? True or not true?
This would be true.
And violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2026 in violation of condition number 4.
How do you plead to that? True or not true?
This is true as well.
All right, did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you grant the state's motion and enter an adjudication of guilt against the defendant, revoke his community supervision and sentence.
All right, and defense, what are you requesting?
We're requesting that the court follow the probation's recommendation, which is to continue him with bi-weekly reporting. It also references a mental health evaluation that was scheduled for May the 4th of 2026. Now, in conferring with my client, he has said that he doesn't see the need for that mental evaluation. As mentioned in the recommendation from probation, it says that when he was reporting, it had mentioned some mental health issues, and that's why that was scheduled. At this current time, He is saying that he has, let me back up. Bottom line is he's saying when he was in jail for about 4.5 months prior to this offense, prior to being placed on deferred adjudication. When he was released, he had lost everything, his apartment. And one of the main things that happened was that he had all of his identifying documents were gone.
So here's
But, and he can speak.
the big question is, why didn't he report? He's been missing since 2025. So that's the number one question.
And what I would say, Your Honor, is that I've advised him of the issues involved with you testifying at this proceeding, but would you like to further expound for the court why it is you were not reporting? Remember, this is what we've been talking about the whole time, that's what the court's gonna wanna know.
Yes,
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
J. David Taylor.
All right, why were you not reporting?
Basically, when I got out of jail, I basically lost everything. I went through an eviction. I lost the car, my phone. They basically just threw all my stuff away, my documents, school transcripts, everything I had worked for. And then I basically missed the first probation, like by 3 or 4 days. So I figured they had a warrant out. So I just wanted to kind of show up to probation with a payment because I had went the first 2 or 3 months and they were requesting like $80.
All right, everyone whisper, we're on the record, I cannot hear. All right, you may continue.
I wanted to at least go to probation with a payment. It was kind of unusual not having employment, but due to not having my documents, I wasn't able to secure a job. So I know it doesn't allow a lack of accountability, but now that I do have some of my documents retrieved, like my birth certificate, I got my social, and I'm working with KRL and Corazon Ministries, and hopefully Haven for Hope will accept me, so I'll have like a place to stay. It shouldn't be a problem in the future.
All right.
And so, Your Honor, we would ask the court to consider continuing him. He also has job prospects. He actually has a job, understanding with factory. And
Correct.
so he had issues, but we think that if the court were to continue him, that it would not be an issue moving forward, Judge. If the court is not inclined to continue him, we would ask the court to consider the minimum.
Well, no. Any questions?
I do. Okay, and so at the time that you were placed on probation, the address that you provided was that you were living at 1 Haven for Hope Way. Is that where you were living at the time?
I was at Haven for Hope. That was the last address, but this would be like 8716 Fairhaven.
Okay.
That was the last address was.
So hold on. So before you went into jail, you were living at Haven for Hope?
No, I was living at Fairhaven.
At Fairhaven, and then when you were released from jail, where did you go? To Haven for Hope?
Well, I was evicted, or I didn't have that apartment anymore on Fairhaven, so I went to Haven for Hope, and they said I needed a referral to get back in since the last time I wasn't there for more than 30 days.
Okay, and then you reported to probation that you were unemployed.
Right.
Okay, so why did you report that if you had a job?
I didn't have a job at the time that I was out of jail. I was in there for 4.5 months, so I didn't have employment at the time or my documents or anything.
So are you saying prior to being in custody at the jail, you had a job?
I would say I was working at the time, where I worked down on Grayson.
Oh, okay. And then you're saying you lost that job as a
Right,
result
yeah,
of being
and being
custody.
in jail for 4 months, they said I was like, no call, no show, so they terminated me.
And then I guess just as a result of you losing your identifying documents and stuff, that's not something that you have to show to probation to report, correct?
Right.
Right. So how did that have an effect on you not?
I would say the first 2 months that I showed up, they were requesting $80. I was always used to, providing and paying rent. So not having a job and then trying to reapply was difficult due to the fact that I didn't have a social, birth certificate or anything. They basically just threw all of my stuff away.
Okay. And then I guess also said that you were scared because you were a couple of days late and you didn't.
Right,
you
the
didn't
last
follow.
probation date, I think around December, whenever I guess prior call to verify the date, I still kind of missed the date by like 3 days or so, so I figured they had a warrant. And I just wanted to kind of gather my documents, et cetera, and at least bring the payment.
Okay.
But
All right, thank you. No further questions.
All right. Court will hear argument.
Judge, we're just asking for you to grant the state's motion and sentence him to 6 years in prison.
Your Honor, we would ask the court to consider probation's recommendations. They know this client. They know his demeanor. They know what he has been doing. One thing that was not mentioned, he was homeless at the time, living under the bridge. Is that correct? Right. So there were some significant transportation issues. But we would ask the court to consider probation's recommendation of having him to report bi-weekly. He understands that if he were to violate again, that he is still facing a full range of punishment. If the court is not inclined to continue him on his probation, we would ask the court to consider the minimum here, which will be 2 years based on the actual offense, which he has yet to be adjudicated for, but that he did plead guilty to, or no contest.
All right. I never understand how someone, if you didn't report for all this time, I don't understand how, okay, we're gonna make them report double means, helps with anything. I don't see that as being rehabilitation. All right, this is what the court is going to do. The court is going to grant the state's motion, revoke, find you guilty. There's to be no contact with Erica Aguilar, no contact with the Dollar General. The court will request the therapeutic community, and the court will sentence you to 4 years in the prison, give you credit for any time served. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, and I'll retain jurisdiction. All right, thank you. Court is calling 2026 CR 003-113 State versus. How do you pronounce your name?
Carlisle
And the last name?
Klarner.
Oh, okay, thank you. Carlisle Klarner, could I have parties announced?
Florida Espinoza for the state.
Jerry Valdez Jr. for Mr. Klarner.
And are you Mr. Klarner?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
Mr. Klarner, did you review the application? Counsel, I'm sorry, I need you to sign. Mr. Klarner, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Klarner, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is from 180 days in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he is, and he was.
Mr. Klarner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. The court will find that the state is in compliance with discovery. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at an $800 fine probated. State recommends deferred adjudication. There is $65 restitution to the Bear County Crime Lab for drug testing. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication before a term of 2 years, there be a TAP evaluation, 100 hours of community service restitution, the DOEP course, and regular random UAs. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, plead offer states exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Parn right now is unemployed, Your Honor, and it's because he's at Haven for Hope right now. He's in a drug rehabilitation program. It's gonna last approximately 3 months. He's been in there almost a month, Your Honor. So right now, while he's in there, they're not allowing him to work. So, because of the program. So
All
we're
right.
asking the court to take that into consideration right now.
What program are you in?
ITP,
Okay.
it's through Haven for Hope. It's on campus.
You said ITP?
Yes, ma'am.
Do you have any children?
No, ma'am.
All right, this is what the court is going to do. 2 years deferred adjudication, $800 fine to be probated, continued participation in the ITP program through Haven for Hope. You're going to need to sign a release so that probation can have information, you understand?
Yes, ma'am. Yes, ma'am.
Regular reporting by Zoom or in person, regular random UAs, proof of employment within 65 days, within 40 days of release from the program. $100 of community service restitution. With a deduction of 1 hour for every sober support meeting that is completed. Field visits 1 time per month for 6 months. There's $65 restitution to the Bear County Crime Lab for drug testing. Probation, is there anything else?
Sorry.
100 hours.
Nothing else.
And of course, with the employment, no employment as a home health care provider or with minors. And no unsupervised contact with minors. Is there anything else that you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So just make sure that you stay on top of that program. Because if you start backsliding, then you look up, you're off track, okay?
Yes, yes, Your Honor.
And the other thing, get a handbook on the rules of the road when you ride a bicycle, right? A lot of people think you're allowed to ride bicycles on sidewalks, but you're not. That's one rule. The other rule they have is if you are walking, you are not allowed to walk in the street if a sidewalk is provided. So anytime you do that, an officer can stop you. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you so much.
You're welcome. Court is calling 2022 CR 6907B State versus Isaiah Ledesma. Could I have parties announced for the record?
Lauren Espinoza for the state.
I'm reporter for Mr. Ledesma.
And are you Mr. Ledesma?
Yes, ma'am.
All right, Mr. Porter has been appointed to represent you, and he was just appointed to represent you today. Your attorney does have certain rights, or I should say you have certain rights through your attorney, and one of them is notice and a chance to prepare. So I can reset this case so your attorney will have more time, or we can proceed today. Which would you prefer?
Proceed to the.
All right, and
Okay.
defense? Okay. All right, Mr. Ledesma, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Isaiah Roman Ledesma who was placed on deferred adjudication in 2022 CR 6907B for the offense of robbery on October 18, 2022 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the month of December 2022 in violation of condition number 4.
I just wanted to make sure, Judge, that's going to be on the First Amendment.
Oh, it's the First Amendment?
Yes, Judge.
All right, I don't have the First Amendment. All right, did you review the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
All right, state, you may continue.
Okay, violated condition number 4. In Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the month of January 2023 in violation of condition number 4.
All right, how do you plead to that, true or not true?
True.
Violated condition number 4 in Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, July, August, September, October, November, and December 2023 in violation of condition number 4.
How do you plead to that, true or not true?
True.
Finally, violated condition number 4 in Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2024 in violation of condition number 4.
How do you plead to that, true or not true?
True.
State will waive the remaining allegations.
All right, and that's a violation of number 4, is that correct?
Correct.
All right, any objection to the waivers?
No, Judge.
Did you understand by pleading true to those violations, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4, 4, 4, and 4?
Yes.
Court will find 4, 4, 4, and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke supervision, and sentence to 6 years TDC to run concurrent with Guadalupe County Cause number CCL 250532.
Is that the agreement?
That is right, Judge.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, so I have a question. Probation. It says that there is to be restitution to Isaiah Miramontes. Was there any restitution ever ordered? Okay. All right, this is what the court would do. The court is going to find you guilty, grant the motion, sentence you to 6 years in the prison. This will run a concurrent with Guadalupe County County Cause number CCL 250532. There's to be no contact with Malik Lampkin, Jennifer Trevino, or Isaiah Miramontes. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better choices.
Judge,
Yes.
one thing I just wanted to make clear,
Mhm.
and I think the clerk has already changed that. This MTR was,
Just 1 second. Cindy, we're still on the record. Okay. Go ahead.
this MTR was filed, the amended one in May. He'd been in Guadalupe County for some 15 months already.
Mhm.
Jail, and when he took his plea, it was on his accord that he actually wrote the district attorney's office a letter saying, hey, can we do something about this? I wanted to make sure he was gonna get the credit for the 15 months that he had sat in the jail going to this case. You know, that the numbers we're talking about over here.
Okay, so let me ask you. The original motion to revoke, not the amended, when he was in custody, had that already been filed or no?
The original one was filed back in.
25-26.
It was February 28th, 2023,
Okay, and so February 8th, when?
of 2023.
All right, and so when was he in Guadalupe?
Then he got picked up in November 2024. And
Yes.
since from 2024 to present, he has been incarcerated.
So yes, he'll receive all that time.
Thank you, Judge.
All right, and they'll just make sure that the clerks have it correctly. If for some reason, when you're transported, you'll see what your time is. If for some reason you feel like it's not correct, just let us know, and it'll be easily corrected, but the clerks should know how much time. And counsel, once they do the judgment, if you want to bring it back to me if you have any issues. And so we'll be able to know, okay?
Yes,
Do you have any questions?
no, ma'am. Thank you.
All right, you're welcome. Good luck to you.
Isaiah Ledesma stood before the court already on deferred adjudication for robbery, but his record told a different story. Months and months of missed probation reports. One by one, he admitted every violation, fully aware it could cost him up to 20 years behind bars. The plea deal was already set. 6 years in prison, no arguments, no appeal. Just like that, what started as supervision turned into a full conviction and a hard lesson in ignoring second chances.